Hello and welcome back to the channel. Today I would like to go over the initial filing from June 26th of 2025 for the redacted order on defendant's offer of proof, the alternate perpetrators. It's the State of Idaho versus Bryan Kohberger, and it was filed on June 26, 2025. The defense sought to introduce evidence suggesting that there were four alternative individuals that could be responsible for the crime, rather than the defendant, Bryan Kohberger. Now, we know since Bryan Kohberger has placed himself in a position to take a plea deal, the prosecution has opposed the idea that there were alternative individuals that could have been responsible for the homicides, arguing that evidence failed to meet any of Idaho's established legal standards under the case State versus Meister. So I'm going to go over the summary and then I'll go back and read the documentation. The court found the defense's evidence insufficient. It emphasized that three individuals had social connections to one or more victims, interacted with victims shortly before the homicides, and lived nearby. They knew the layout of the victim's home. However, none had a proven motive. No direct physical evidence tied them to the crime scene, and all of them had cooperated with the law enforcement fully. Their DNA did not match any samples from the crime scene either. The fourth individual had a minimal connection to one victim. He briefly observed her at a store weeks before the homicides, but never actually interacted with her directly. He's also corroborated fully, and his DNA was also excluded. The court ruled this evidence was going to be irrelevant and speculative at best, and definitely inadmissible. Even the slightest possibility of relevance was outweighed by the risk of misleading the jury or confusing issues or causing unfair prejudice. The court denied the defense's offer of proof regarding these alternative perpetrators. The ruling does not, however, prevent the defense from challenging law enforcement's investigative thoroughness and exploring whether plausible leads were overlooked. Such inquiries must remain general and avoid targeting specific individuals unless approved beforehand by the court. Although now he's taken a plea agreement, it's really null and void. The defendant's offer of proof regarding alternative perpetrators was officially denied by the judge on June 26 of 2025. The state previously moved in limine seeking to preclude defendant from offering or arguing alternative perpetrator evidence without first satisfying the applicable evidentiary standards. In accordance with the court's subsequent order on the motion, defendant filed his offer of proof and evidence in support, identifying four individuals as potential alternate perpetrators. The state objects to the presentation of this evidence at trial, arguing it fails to satisfy the standard under State versus Meister. Defendant conceded at oral argument that at this point his proffer is not sufficient to pursue an alternate perpetrator theory at the outset of trial, but requests latitude in cross-examination of the state's witnesses to try to establish additional evidence to satisfy the Meister standard. The court concludes that, at this time, defendant's alternate perpetrator proffer is inadmissible under Meister, as it is irrelevant and/or excluded by IRE 403. However, this does not foreclose defendant from cross-examining law enforcement regarding the reasonableness of its investigation and its follow-up on plausible leads. Standard. Trial courts have broad discretion in the admission of evidence at trial. Trial courts have broad discretion in the admission of evidence at trial. Carlson versus Harris. A trial court acts within the bounds of its discretion when it 1. Correctly perceived the issue as one of discretion, 2. Acted within the outer boundaries of its discretion, acted consistently with the legal standards applicable to the specific choices available to it, and 4. Reached its decision by the exercise of reason. Lundenberg versus My Fun Life. Analysis. The seminal Idaho case on the admissibility of alternative perpetrator evidence is Meister. Prior to Meister, a defendant wishing to present such evidence at trial had to first present proof of connection with the crime, such a train of facts or circumstances as tend clearly to point out someone besides the accused as a guilty party. Remote acts, disconnected and outside of the crime itself, cannot be separately proved for such a purpose. State versus Larson. Meister clarified that the Idaho rules of evidence, rather than the more onerous Larson standard, control alternative perpetrator evidence admissibility. Under these rules, evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. State versus Garcia. Idaho Rule of Evidence 403 governs the exclusion of relevant evidence and permits a court to exclude evidence if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Meister further offered the following guidance on applying these rules and determining whether proffered alternative perpetrator evidence is relevant and admissible. If the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant's involvement more probable or less probable, then it is within the trial's court discretion to find the evidence inadmissible. Mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitations provided of IRE 403. A defendant has no right to present irrelevant evidence, and even if evidence is relevant, it may be excluded in certain cases. The Idaho Rules of Evidence effectively safeguard against the admission of conjectural inferences without the lower courts needing to apply the Larson direct connection doctrine. State versus Meister. Here, the evidence defendant has offered purporting to establish the four individuals as alternate perpetrators objectively fails to meet the Meister standard. Namely, the evidence is entirely irrelevant. Nothing links these individuals to the homicides or otherwise gives rise to a reasonable inference that they committed the crime. Indeed, it would take nothing short of rank speculation by the jury to make such a finding. Three of the individuals were socially connected to one or more of the victims, interacted with one or more of the victims at social events in the house prior to the homicide, lived within walking distance of the crime scene, and were familiar with the layout of the victim's home from prior social events. While perhaps this evidence could suggest an opportunity to commit the crime, which no doubt is an opportunity shared by dozens of others in the victim's social circles, there is no compelling evidence that any of them had a motive to kill the victims, much less physically harm them, or a means to do so. Further, there is no evidence connecting them to the crime scene. They have each cooperated with law enforcement, providing DNA samples, fingerprints, and allowing searches as requested. Notably, lab testing has excluded their DNA from samples taken from the crime scene and victims. The fourth individual did not know the victims, but had a passing connection to one of them while noticing her shopping at a store approximately 5 weeks prior to the homicides. He followed her briefly out the exit of the store while considering approaching her to talk. He turned away before ever speaking to her. The event was captured on a surveillance camera. This individual subsequently cooperated with law enforcement, providing his phone number and a DNA sample. As with the other alleged alternative perpetrators, the lab reports excluded his DNA from the samples taken from the crime scene and victims, and there is no evidence connecting him to the crime scene. Collectively, defendants proffer with regard to these four individuals failed to give rise to even an inference that they committed the crimes or otherwise make it more or less likely that defendant was the perpetrator. Therefore, it's irrelevant under IRE 401. Defendant has provided no probative, admissible, significant evidence of motive, ill feelings, means, presence at the scene, or any other connection to the crime that could possibly move the ball to the extent it supports an alternative perpetrator theory. At best, defendant's offer of proof can give rise to only wild speculation that it is possible any of these four individuals could have committed the crimes, which is inadequate under Meister. Again, mere inferences that another person could have committed the crime will most likely not be relevant. In other words, it's not sufficient for a defendant to merely offer up unsupported speculation that another person may have committed the crime, which is all the defendant has done here. Even if there was a shred of probative value in the proffered evidence beyond wild speculation, it is excluded by IRE 403, as the Tenth Circuit noted regarding alternative perpetrator evidence. It is not sufficient for a defendant merely to offer up unsupported speculation that another person may have done the crime. Such speculative blaming intensifies the grave risk of jury confusion, and it invites the jury to render its findings based on emotion or prejudice. United States versus McVeigh. Likewise, here, presentation of the proffered alternate perpetrator evidence would pose a great threat of confusing the issues because it would force the state to defend against a nebulous allegation that perhaps these individuals were involved. This foray would lead the jury astray, turning its focus away from whether defendant, the only person whose actions are on trial, committed the charged crimes. It also presents a threat of unfair prejudice, as it would invite the jury to blame unrepresented persons for a heinous crime when there is not a scintilla of competent evidence connecting them to the crime. Finally, it would do nothing more than waste the precious time of the jury and the court in what is already a scheduled 3-month trial. Nonetheless, the court's ruling does not preclude defendant from confronting and cross-examining the state's law enforcement witnesses regarding the thoroughness of the investigation, particularly in follow-up on ruling and out leads generally. Indeed, the Idaho Court of Appeals recently found in an unpublished opinion that questioning a detective about failing to follow up on other plausible leads was relevant to alternative perpetrator analysis. We agree with Emerson that a relevant line of inquiry would be to question the scope and breadth of the investigation, and to explore on cross-examination whether plausible investigative leads about third parties were ignored or overlooked. State versus Buck. It further stated that this line of questioning may not include inquiries about the investigation of specific third parties absent satisfying Meister, noting, while evidence challenging the thoroughness and reliability of the investigation might be probative, questioning whether law enforcement investigated specific individuals with no connection to the murder provided no probative evidence. Moreover, with no connection between the evidence and the crime, there is no explanation or justification for the questioning, and it would not help the jury answer the only questions in the case, whether Emerson killed James. The court will apply these same parameters at trial regarding defendant's cross-examination of law enforcement. He may inquire as to the reasonableness of the investigation, including the investigating and ruling out other leads. He is not, however, permitted to question law enforcement about the investigation of any specific individual as a potential alternate perpetrator without first raising the matter with the court outside the jury's presence. Order, based on the foregoing, defendant's officer of proof, alternate perpetrator is denied. Let me know if you found any value to the reading of the document. As always, thank you for hanging with Theo.